Hi and welcome. Would you please state your name and profession?
I'm Stefan Ruech. I'm a case handler in the legal service of the Austrian Federal Competition Authority.
And how come you specialize in competition law?
I think it's a very diverse field of law. It ranges from merger control to cartel and antitrust investigations. You deal with questions of administrative law and even human rights law when you look at down rates, for example. And I think it's also a field of law which reacts quite quickly to social change, looking at digital mergers, for example.
So that actually leads us right to my next question, which is, in your experience as an antitrust enforcer, how relevant have digital mergers become? And what sets these mergers apart from mergers in more traditional markets that might make their assessment more challenging?
Looking at relevance, I would say undertakings active in the digital market, they are actually quite active buying other companies. You just have to look at the big five like Alphabet, Google, Microsoft, and so on, and they've acquired more than 800 businesses. So I think they are actually, digital mergers are very relevant.
And what about their assessment? Are they more challenging as an enforcer?
I think when you look at the challenges with regard to digital mergers, I think actually two areas. I think one area is actually getting a competition enforcer in the position to review such transactions. It often concerns young startups which are still figuring out a way to monetize their services, and for that reason have low or no turnover at all. And most merger control regimes actually still rely on turnover-based thresholds only. So it is difficult for them actually to capture those transactions, and most of those cases actually fly below the radar. In Austria and in Germany, the legislator reacted and introduced, as you know, the transaction value threshold. Also at the European level, you have the new, or depending on your position, reviving an old approach with regard to Article 22 referrals. However, still there are a lot of merger control regimes still are simply not able to capture those transactions. So I think that is one of the challenges looking at digital mergers. And once a transaction actually has been notified, I think it's a challenge is that it often concerns very dynamic, very fast-moving markets. And those instruments which we used in assessing traditional mergers might not be such a good fit for digital mergers. For example, looking at market definition in the context of platforms, as you know, or how relevant market shares are. So I think at the end, the challenge is to find the right balance to ensure effective competition.
Exactly, and that's actually something we're going to discuss in just a moment. For the next question, please only provide a two-word answer. Tech giants, more enforcement or less enforcement?
If I only can choose between those two, I would go for more enforcement, but the words which I would actually take would be earlier and faster.
Okay, excellent. Now, last but not least, what is the one thing that every competition lawyer should know about merger control in Austria?
I can put that quite simply. It's non-controlling minority shareholdings matter.
Excellent. Thank you so much. We're looking forward to the discussion later.
Thanks.